Here.
And I'm not going to begin to try and pronounce the last name of appellant's counsel. Its first name is Joseph. I got that right?
Oh no, so Your Honor, that's my trial counsel. My name is Nick McNamara.
Okay.
With Creed and Gowdy.
I could have done that. All right, Mr. McNamara, is 5 minutes good for rebuttal?
Yes, that's good, Your Honor.
All right, you may proceed.
Thank you, and may it please the court, Nick McNamara on behalf of the plaintiff, Carl Macia. We're here on two issues, one procedural and one substantive. I'd like to address the procedural issue first, which is that the trial court abused its discretion by granting a final summary judgment without addressing Mr. Macia's pending motion for leave to amend his complaint. Originally, Mr. Macia had just the negligent hiring claim against the South Carolina affiliate of Century Aluminum, which is at issue in our second issue. But he moved for leave to amend to assert various vicarious liability claims and joint venture claims against South Carolina Century, as well as its parent company, Century Aluminum, its sister company, Kentucky Century, and Lucas Trucking, the employer of the active tortfeasor in this case.
Why would not the proposed amendments have been futile?
Well, the proposed amendments would not have been futile because, I mean, we lay it out in our brief. These are related to the same transaction, the same occurrence here. The vicarious liability is very similar to negligent selection in that both seek to hold the employing party liable for the entirety of the active tortfeasor's negligence. But I just wanted to say that, the trial court never got to address the motion for leave on the merits. It effectively denied it without reaching the merits by granting final summary judgment.
Well, counsel, there is some procedural, quirks, for lack of a better term here. I mean, this went on, there was a motion for summary judgment, a year went by in between the time that the order was entered, or the hearing and the order was entered. There were attempts to have this motion heard. It does not appear as though that ever happened. But then, in the face of the order, it indicated that the court had granted it and essentially moved on. And that was kind of embedded within this summary judgment order. Is that an accurate statement?
So, Your Honor, that is in the court's kind of statement of the procedural history, and this wasn't really addressed by the parties in their briefing. It was sort of confusing what the trial court was saying in its order. But what I would respond to that is we're not here to challenge the trial judge's findings or recitation of the procedural history of the case. We're just here to say that the trial court erred, despite us asking 4 times by my count to rule on the pending motion for leave to amend before granting final summary judgment.
But they think that they did, and you didn't bring it to the trial court's attention. Is that issue not waived? It appears as though that's what they thought, is that they had in fact heard the motion, granted it, and now they were free to enter judgment, is what it seemed like.
I would say it's not waived, Your Honor, just because we had previously asked the court to do exactly what it didn't do. And we cite the cases from the 2nd DCA and the 4th DCA, respectively, the Kimball case and the Skilled Services case.
But those cases don't address my question, correct?
They do not. But, in either of those cases, it could have been inadvertence on the part of the trial judge. We don't know. But the court said that it was an abuse of discretion to deny to grant final summary judgment before ruling on the pending motion for leave to amend.
So is it your argument, counsel, that because it was in the same order that it wasn't before, so it's wrong? I'm just trying to parse that out.
My position is that this is not an error that appears for the first time on the face of the order, because this is something that we had previously argued. In all the cases that I'm aware of.
Did you get a ruling on that?
On the motion for leave to amend?
Right, the fact that you argued it before, is that relevant in the preservation?
Well, we effectively got a ruling on it because we asked the court to, instead of granting final summary judgment, at least consider the pending motion for leave to amend. It was part and parcel of the relief that we asked for. And so we cite the cases that talk about how when the trial court enters judgment and there's a pending motion that's inconsistent with that judgment, then it's deemed denied implicitly. That's the City of Plant City case from the Florida Supreme Court and the Reevman case from the 3rd DCA.
But how do you implicitly deny something when subparagraph 8 states, on January 19, 2024, the court heard plaintiff's motion for leave to file second amended complaint and several discovery motions which the court granted?
Sure, I think that the court may have made a mistake in its recitation of the procedural history, but by granting final summary judgment, that means our motion for leave to amend is off the table. And you also have to look at how long this has been going. We filed our motion for leave to amend back in February of 2023. The court did not rule on the motion for summary judgment until June of 2024. We had previously asked on 2 separate occasions in the interim to have a hearing on the motion for leave to amend, and so this has been going and going and going. And so if we were to file a motion for rehearing directed to the final judgment, I mean, who knows when the trial court would have ruled on that. So
does that mean that it's preserved because you don't know how long it would have taken? Because it seems pretty apparent that because there was a hearing on January 19th, 2024, where it was supposed to be heard and it was not.
That's
it appears as though this is an error, an absolute error by the trial judge, because a year had gone by and, as you said, multiple things had occurred. So should now say it's implicitly denied without giving the trial judge that opportunity on the specific issue that appeared for the first time here. It is your position that that's still preserved for us now.
It is, Your Honor, just because of I'm not aware of any case applying that doctrine you're talking about, the issues appearing for the first time on the face of the record, where the argument had previously been made by the appealing party. And I'd say, that Kimball case and the skilled services case, we don't know why the judge didn't rule on the motion for leave to amend in those cases. It was the second DCA and fourth DCA held that was reversible error. But I did also want to address the second issue here, unless Your Honors had any further questions about the first issue. All right. So the second issue is we believe that the trial court erred on the merits of the summary judgment order. The court found as a matter of law that plaintiff lacked evidence of proximate causation based on this court's decision in Davies versus Commercial Metals. But I'd like to, before kind of getting into the weeds with Davies, I'd like to discuss some background principles of proximate causation. Proximate causation it's all about foreseeability. And as the Florida Supreme Court said in McCain in 1992, it is immaterial that the defendant could not foresee the precise manner in which the injury occurred or its exact extent. A harm is foreseeable if human experience teaches that the same harm can be expected if the same act or omission is repeated in a similar context. Here, unlike in the Davies case, we have a motor carrier that's been issued what's called a conditional safety rating by the Federal Motor Carrier Safety Administration. And what a conditional safety rating says is that a motor carrier does not have adequate safety management controls in place to ensure compliance with the safety fitness standard that could result in occurrences listed in Section 385.5 A through K. And if you look at that list of occurrences that are risked if you have a conditional safety rating, we're relying on sub K here, which is motor vehicle accidents and hazardous material incidents. We're relying on the motor vehicle accidents part. So you have a determination by a federal agency that this, after performing an inspection, conditional safety rating is not something that is automatic after you violate a federal safety regulation. There's a process, and that's laid out in 49 CFR 385.7. Multiple factors are considered. So this is a judgment call by the Federal Motor Carrier Safety Administration that this motor carrier, Lucas Trucking, lacks safety management controls, and that lack of safety management controls makes it foreseeable that the things listed in A through K could occur, including motor vehicle accidents. In the Davies case, there was no such determination. There was no way for the shipper to foresee that this was a risky carrier. There was a history of violations there, but there was no designation that hey, world, this carrier is a risky carrier, and if you hire them, you're exposing yourself to this list of risks. And so I'd like to address some cases that I think are helpful on this. We have the Stahl versus Metro Dade case. That's from the 3rd DCA, 1983, and it talks about how proximate causation is all about is it fair for this defendant to be held liable for the consequences of its actions? I think it's undisputed that South Carolina Century's decision to hire Lucas Trucking to haul this load was the but-for cause, but now we have to...
The load had already been delivered, correct, when the accident occurred? The
That's
load had long been delivered, and the driver was returning to base, correct?
That's correct, Your Honor.
And I went to pick up another load, correct?
That wasn't really something that we developed because that would go more to the vicarious liability claims. We cite cases that talk about how in the negligent hiring context, it doesn't matter whether or not the negligence occurred within the course and scope of the engagement. And I think a great example of that is the Tallahassee Furniture versus Harrison case from the 1st DCA, which involved a furniture deliveryman who had previously made a delivery to a customer through his employer, and then later on went to the customer's home. She let him inside, and then he battered her. That was completely outside of his employment with Tallahassee Furniture, but the court said that in a negligent hiring case, unlike in a vicarious liability case, the issue is whether the employer's actions brought the tortfeasor in contact with the plaintiff. And I think it's undisputed here that Century Aluminum hired Mr. Lucas to transport its load, and it is completely foreseeable that an accident could occur, whether it's during the delivery of the load to its destination or on the way home, because that is a necessary component of a delivery.
What if Mr. Lucas stops at a bar en route to the way home, gets drunk, and then when he's driving from the bar to home, he is involved in an accident? Does that mean the appellee in this case is on the hook?
I think that would be different, because I think that would be an intervening cause. I don't think that's reasonably foreseeable that someone who drives a commercial motor vehicle would stop at a bar and then proceed to drive his 18-wheeler home. But in this case, there was testimony though about how this was a regular thing for Mr. Lucas. He regularly hauled loads, and the loads would be dropped off at his trucking yard, and then he would take him by his colleague, and then he would take them to their final destination and bring them back. And so in order to keep picking up loads, he would have to come back to his garage. But I would submit that, Your Honors, that's outside the the record right now because we never got to plead our vicarious liability claims, which is really where that course and scope of employment comes into play. But in terms of, as far as the negligent hiring claim goes, I think that is a red herring that Mr. that Mr. Lucas was returning from delivering the load. And so I see them running up to my time for rebuttal, but I just wanted to point out one more thing that I think is a useful analogy is, that in a negligent security case, you don't have to show that there were prior similar incidences on the premises. You just have to show that maybe there was other crimes that were committed around the premises, but there doesn't have to be an exact match between the crime that occurs and prior crimes, and that is stated in the Patterson v. Deeb case from the first DCA. And so I will use the rest of my time for rebuttal. Thank you, Your Honor.
Thank you. Mr. Perkins.
May it please the court, my name is Brandon Perkins. I represent Century Aluminum of South Carolina. I would like to address a couple of the cases that Appellant's Counsel brought up just to distinguish them. The first is the Tallahassee Furniture case. Let me explain a little bit about the facts of Tallahassee Furniture. There was a furniture delivery at a woman's apartment. The delivery person was let in, made the delivery, a couple days later comes back and says, here's a TV I was going to throw away, do you want it? She lets him in and there's an assault that occurs. And ultimately they said, the furniture company could be held liable under this theory of, negligent hiring. But the reason is the furniture company put that bad actor in direct contact with that plaintiff, sent that bad actor to the plaintiff's home. So it established this idea of putting somebody in contact. Unlike what we have here, where we have Century Aluminum in South Carolina, they're shipping aluminum billets down to Florida. The billets are delivered where they're supposed to go according to the bill of lading. After they're delivered, delivery driver's almost back to its home base, making a right turn from the left lane, crosses the right lane with the semi. This unfortunate accident occurs. There's nothing that Century Aluminum of South Carolina did that put the Lucas Trucking or the driver in direct contact with the plaintiff here. The other case I'd like to distinguish or situation is counsel quoted I believe Deeb's case, a negligent security case. Negligent security law is very different than what we're dealing with here. And the reason it's different is anybody who possesses a premise, and by possession I'm going to say that means the right to control access of who comes on the premise. Anybody who has that right is going to owe a duty if there is a reasonable chance that there's going to be criminal activity. So if you can reasonably foresee crime occurring, then you're going to owe a duty to those specific plaintiffs that you invite on. You don't owe that same duty to trespassers. Duty's a little bit different with licensees, but to invitees you owe this duty. It's more of a direct liability, non-delegable duty situation. With negligent hiring and entrustment like we're dealing with here, if you hire, like Century Aluminum of South Carolina, they hire a motor carrier to move a load, there could be a duty related to making sure that there's not any particular incompetencies that would make this motor carrier dangerous to the traveling public. Now here, this motor carrier, Lucas Trucking, had what's known as a conditional safety rating by the Federal Motor Carrier Safety Administration. There's three types of ratings. Most carriers are unrated. They just drive around, nobody's ever rated them, unrated carrier. Some carriers have a conditional safety rating. That means there's something that they could be doing better. There's some level of incompetency. And then there's, you could be rated as satisfactory. You can't really go in and ask for a satisfactory rating. It's kind of after you get a deficiency, if you improve so much, they'll give you a satisfactory. Very few have this satisfactory rating. I point out this background because what a lot of times plaintiffs' counsels do in trucking cases, and they're doing here, is they make it seem like a conditional safety rating is just terrible. It's an unfit driver. The Federal Motor Safety Carrier Administration should pull their license and not allow for any loads. It would be negligent to hire them. It's not the case. So if we look at the facts of this case, why was Lucas Trucking, why did they have a conditional safety rating? Well, we know that. Hours of service of drivers, inspection, repair, and maintenance, controlled substance use and testing. These are the three areas. These are paperwork areas on what could be done better. Better logging of the hours, better logging of the inspections, better logging that controlled substances were being tested and the drivers weren't using controlled substances. Now, the reason that this is important of the why they were issued a conditional safety rating is because the accident happened through ordinary negligence, making a right-hand turn from a left lane. Nothing to do with controlled substances, nothing to do with the vehicle inspection and repair, nothing to do with the driver being over the hours of service. This was just pure negligence. Now, under the Federal Motor Carrier Safety Administration, there are parts that address the use of unqualified drivers, that's Part 391. Improper use and driving of motor vehicles, that's Part 392. And unsafe vehicles, that's Part 393. Lucas Trucking wasn't cited under any of these parts. The reason this matters is because of what this court said in Davies versus Commercial Metals. Whatever it is that made, whatever particular incompetence it was that made it negligent for the shipper to select that particular motor carrier, that particular incompetence would need to have a result in the harm to the plaintiff. You have to have that nexus there. And in Davies versus Commercial Motors, it was an almost identical set of facts. Shipper, Commercial Metals, wants to haul scrap metal. They hire a company, C&W Trucking, to haul the scrap metal. As the metal is actually being hauled, that's a distinguishing factor. The driver pulls off onto the shoulder, and as he's entering the road, he pulls into the lane of travel. A car rear ends him and is injured or killed. And we're looking at, can we hold the shipper liable for this? And the plaintiff, in their complaint in Davies, it's quoted, paragraph 39 of the complaint in Davies, it says, it is alleged that Commercial Metals knew or should have known about the poor safety performance record of its chosen carrier. The complaint goes on to suggest that the poor safety performance record has to do with this maintenance of the vehicle. And what the court ultimately says is, this is one of those rare situations where the particular incompetence, what made it incompetent for C&W Metals to select, what made it particularly incompetent for Commercial Metals to select C&W as a motor carrier, had nothing to do with the plaintiff's injuries and how this accident occurred. It occurred through straight, ordinary negligence, pulling onto the road when you shouldn't have.
Based on the Davies opinion from this court, is there any dispute in the record before us that the particular incompetencies, in this case, driving log maintenance records, substance testing records, has any nexus whatsoever to this accident?
There is no dispute. It has zero nexus.
Plaintiff concedes that.
Plaintiff concedes that. And here's where I get that from. The judge in this case asked for supplemental briefing. And if you read the whole transcript, the judge was asking the plaintiff's counsel, what you're essentially saying, and are you arguing strict liability? Because you're throwing out conditional safety rating, but I don't see it linked up. And the plaintiff's counsel was saying, no, well, because there's a conditional safety rating, that puts the world on notice this is an unsafe carrier. So they went from these particular incompetences to the general unsafe carrier, back to the specific ordinary negligence of motor vehicle accident should have been foreseeable. And the judge was saying, if you do that, aren't you at strict liability? Because anytime you have this particular incompetence, regardless of if it had anything to do with the accident, it's going to create a jury question on proximate cause. And the plaintiff said, no, we're not arguing strict liability, Judge. So the judge said, okay, I want supplemental briefing. And here's what I want you to brief. And I wrote it down because it's important. You know, the judge said, I want you to address the issues related to the conditional safety rating of Lucas Garage, whether any of those deficiencies that purportedly led to a conditional safety rating existed, and if so, whether they matter for the purposes of establishing legal liability of any of the defendants in this action. Then the court went one step further and said, I'm not precluding you from the argument that it doesn't matter in any event, somehow similar to vicarious liability, as you know, so employee, independent contractor, joint venture, those duties, all right, the whole ball of wax. So what the court was saying is, do supplemental briefing, tell me, did any of these incompetencies, did they exist at the time? Did they cause the accident? And if they didn't cause the accident or does it even matter because of vicarious liability and other theories you may have against these defendants? The plaintiff says, well, it doesn't matter in any event, but didn't address any of the vicarious liability counts. But they never said, gee, Judge, the accident occurred because of alcohol in the system, or the driver was over the log books, or the truck was malfunctioning. Never put on any evidence, never showed anything in the record. So that's established for the purposes of, the summary judgment hearing. So after this court, in this court's opinion in Davies, the court quoted 411 of the restatement. Of course, 411 of the restatement is the law in Florida. It quoted with approval 411, and 411 explains when a shipper might be liable for selecting an independent contractor who gets into an accident. And section 411, the comment B, talks about the scope of the liability. And then there's illustrations. And I quote in the brief illustrations 3, 4, and 5 because they're applicable. Comment B, what it says is the same thing that this court's opinion in Davies says. You have to have a particular incompetence that causes the harm. Otherwise, that's beyond the scope of a claim under section 411. And then illustration 3 talks about hiring a bus company to transport people from the train station to a hotel. And the hotel owner knows that the bus company has one driver who's inexperienced at driving. So if the bus gets into an accident and the accident is due to inexperience, hotel's liable. If the driver gets into an accident and it's due to something else, let's say poorly maintained bus, hotel's not liable. There has to be a nexus between the particular incompetence and the plaintiff's harm. We don't have that here. Plaintiff cites a slew of cases from out of state in its brief, suggesting that the law in Florida is different. I couldn't tell if they were saying that Davies was wrong or right or being misinterpreted. Anyway, Jones versus Worldwide is an example. But in Jones versus Worldwide, there was a nexus between the particular incompetence. The driver had just obtained his commercial license, and an accident happened because the driver was inexperienced. Stallings, the driver had a history of unsafe driving practices, and unsafe driving was a factor. Berkey, the history of speeding the driver had, and speeding was a factor. So once again, the particular incompetence related to the specific accident. So the trial judge was clearly correct in granting summary judgment on the negligent hiring and selection claim. As far as the motion for leave to amend, the trial judge was also correct in granting summary judgment despite that motion. Now, in candor to the court, I looked at the same thing that Judge Kilbane did when I read the record. I was not trial counsel, and I said, oh, the motion to amend was granted. So I go back to the hearing. I read the transcript, and I say, gee, I can't see on the transcript where it said granted. I can't see an order. I'm going to catch 22. Well, not really, because I look at it and I see it as obviously either a mistake that the trial judge made thinking he granted it, or on the other hand, the trial judge says, doesn't really matter. I asked him to address everything. I said, the whole ball of wax, vicarious liability, joint venture, address it all and tell me whether it matters that there's a nexus between what made it negligent to select this Lucas Trucking and the harm. The plaintiff didn't do that, so really it doesn't matter one way or the other. If the judge did not grant the motion for leave to amend, and if it was truly pending at the time, the final judgment would make it denied, but it wouldn't be error. For a couple reasons. Number one, the amendment itself would be futile. I went through that in the brief of why it was futile. Essentially, everything that they argue as far as agency joint venture goes could apply to any shipper. Anybody who ships something through UPS, DHL, FedEx, they've taken innocuous facts like, in this case, they say Lucas Trucking agreed to move the goods, whereas Century Aluminum is selling them, and they're combining their efforts and resources. Nothing specific to establish that there's a partnership to move this particular good or this line of goods, and they're agreeing to share in the profits and losses. It was a threadbare recitation of elements in the complaint with no factual support. The judge understood this because the judge asked for supplemental briefing, asked the plaintiff to explain themselves before granting summary judgment, and plaintiffs couldn't. In addition, I do believe that the issue was waived, as I argued in my brief, because if it was an error, it appeared for the first time on the judgment. So at that point, you have to stop and move for rehearing and say, Judge, you said you granted this and you didn't. Look at what you're doing. This would be error. I'm going to give you the first opportunity to fix it. You don't say it in those words, but that's what you need to do. That wasn't done here, so it was waived. I've got 2 minutes left, Your Honor. I've explained what I felt I should. Everything else is in the brief that maybe I didn't address here. I would ask that you affirm the final judgment that was entered, and I appreciate your time.
McNamara, you've got about 4.5 minutes.
All right, thank you. Just briefly, I wanted to readdress the hypothetical that Judge Wallace brought up, because I think in the heat of the moment I might have misspoken a little bit. So in this case, one of the things Mr. Macia was cited for was lack of drug alcohol testing. So I think in this scenario, your hypothetical, that would be foreseeable, but that's neither here nor there. I think in any other, if there was no I think that, here, it was foreseeable that a risk of a motor vehicle accident would occur based on the conditional safety rating. I wanted to discuss also Tallahassee Furniture. My colleague distinguished that case on the ground that there was direct contact, that the employer's conduct brought the plaintiff in direct contact with the defendant. I mean, I think that's, I haven't seen the words direct contact used. It's all about foreseeability, but even assuming that's the standard, I mean, it was Century Aluminum's decision to hire Lucas Trucking that put Mr. Macia on the road, or Mr. Lucas on the road, and brought him into contact with Mr. Macia. On the Patterson case, I heard a lot of discussion about the duty of the landlord. We're not here to argue duty. It's all about foreseeability. I don't see how the foreseeability analysis in a negligent security case would be any different from a negligent hiring case. I also wanted to talk about how we need to read this court's decision in Davies in line with the Florida Supreme Court's jurisprudence on proximate causation and foreseeability. And it's clear, especially from the McCain decision, that the precise manner in which the injury occurs need not be foreseeable. It just has to be the type of injury has to be foreseeable. And here we have a determination by a federal agency that a motor vehicle accident is a risk that you would incur by placing this motor carrier on the road. I also wanted to address the supplemental briefing issue that my colleague brought up. I think you have to look at the context in which the trial judge was making that statement at the hearing. Century Aluminum, as I explained before, has tried to blend the analysis of the course and scope of employment inquiry with negligent hiring. And that was the context in which the trial judge made those comments. And we argued below in our response that you don't consider the course and scope of employment when it comes to the negligent hiring. That's all about vicarious liability, and the court didn't ask for supplemental briefing on our motion for leave to amend. The court asked for supplemental briefing on the motion for summary judgment, and negligent hiring was the only issue raised by the defendant in their motion for summary judgment. Finally, I would just state that while this court in Davies did rely on Section 411 of the restatement for the elements of negligent hiring, it did not rely on Comment B. And we stated in our brief, I think Comment B is inconsistent with Florida law on proximate causation. Comment B requires you to look at the driver's the tortfeasor's previous history, and there has to be like an exact match between that prior history and the tortious conduct at issue in the case. And I think that just can't be squared with McCain. And so for all these reasons, I would ask that this court reverse the final summary judgment and ask the trial court direct the trial court to address the motion for leave to amend, or alternatively grant the motion for leave to amend. Thank you.
Thank you. Okay, counsel, when you're ready, please introduce yourself to the